Thank you.
All rise. The Honorable Justices Christoph and Abbott of the Supreme Court of the United States now presiding. All those having business before the Honorable Court, draw near and ye shall be heard. This court is now in session.
Be seated. Okay. Before we start, counselors, can you please introduce yourselves?
Yep, I'm John Spangberger on behalf of the petitioner.
I'm Jocelyn Simpson on behalf of the respondent.
Okay. Petitioner.
May it please the court, Your Honor. John Spangberger on behalf of the petitioner. Your Honor, first of all, thank you so much for your time this evening. We truly appreciate that. Your Honor, tonight's discussion focuses on the peaceful protests conducted by Michael Scarn, a passionate young man whose efforts to effect positive change in his community were met with violent and unconstitutional punishments at the hands of DMU. Now, Your Honor, we ask you to find that Dean Howard and Chief Tate were acting under the color of state law when they abused their authority to deprive Michael of his constitutionally protected rights, and moreover, that Michael's conduct is entitled to the protection of the Constitution on the grounds that it was inherently expressive conduct. Now, Your Honor, at this time, with your permission, I'd like to highlight a few key facts for the court.
Please.
Thank you, Your Honor. Your Honor, Michael Scarn is a junior at DMU and one of approximately 5,000 students born outside of the United States. Now, for such a diverse student body, it should come as no surprise that President Wallace's proposed travel ban struck the community extremely hard. Now, DMU was clearly aware of this fact because, responsive to that travel ban, they instituted a complete and total ban on any and all demonstrations, effective immediately, without any kind of warning period to the students.
Is there any correlation between the ban on the protesting and the executive order?
I believe so, Your Honor, given, first of all, the proximity to the travel ban having been announced. Moreover, I believe the respondent addresses in the brief that it was in response to the growing fear of protests around the country in response to the travel ban specifically. And moreover, the fact that the email not only mentioned the complete travel ban, but also reminded the student body of the long-standing demonstration policy was evidence that they had reason to believe that the student body was especially prone to protest in response to that travel ban. Now, Your Honor, Michael Scarn was clearly heartbroken by the prospect of this travel ban, forcing his friends and colleagues to choose between the right to stay in America and receive an education and the ability to return home to see their families. And so he decided to stage a peaceful protest to voice his concerns. Now, in the course of this protest, he sat outside one of his classrooms and he applied duct tape to his mouth and eye and removed his shirt. Now, Michael did not speak at all. He did not disturb anyone. He didn't bar anyone entry into the classroom. He simply sat there in peaceful protest. And yet Dean Howard, clearly upset that his anti-demonstration policy wasn't being strictly observed, summoned Chief Tate to the scene of Michael's protest.
How can we say that it didn't disturb anybody? I mean, if you walked into this courtroom today and you walked past a guy with his shirt off, with tape over his eye and his mouth, wouldn't that be disruptive to you?
It's certainly possible that some of these students were distracted, but I think there are a few other factors to consider. First of all, the final examination period for many students is the pinnacle of their academic year, and I find it likely that many of these students were pinpoint focused on their exams. Moreover, the standard is not simply, as we'll get to later for the constitutionality of this policy, is not simply that it may pose a slight disruption to some students. In fact, we see that the courts have expressly forbid a fear of creating some kind of disturbance. There needs to be evidence of a significant disruption to the student body and the student's right to receive an education in order for a policy banning that conduct to be constitutional.
Don't you think the 25 students who congregated outside of the classroom is exactly the kind of disruption a ban like this was intended to prevent?
Well, Your Honor, there was actually no crowd at all in response to my list protest until Dean Howard came and started to create a scene and drawing those students near. So it would seem to me as though before Dean Howard intervened, there was absolutely no disruption, and in fact the disruption was caused by Dean Howard's policy and not Michael's protest.
So can I just ask you a question? You
Certainly.
mentioned that, did I hear correctly, you said a mere expectation of disruption is not sufficient. Can you talk about that argument a little bit?
Certainly. So in Healy acknowledged the fact that a fear or apprehension of a significant disruption is not sufficient. There needs to be a more plausible chance of a significant disruption occurring. And so in the case at bar, perhaps Dean Howard should have waited to see if any disruption occurred before he intervened.
So this is the Healy case? Is that
That's correct. Healy v. James, I believe.
Okay. And so what were the facts in that case?
So in that case, a group of students wanted to establish a local chapter of, I believe, the Students' Democratic Union. And around the country, college campuses that had local chapters were experiencing violence. And so the president would not allow the local chapter at that college to assemble because he was afraid that similar protests would arise. And that's very close to what we see here, where Dean Howard sees these protests across the country, and he's worried that something similar is going to happen. But again, that fear, without any kind of substantiation or evidence to support it, is simply not sufficient.
But are there other protests around the country of people putting tape over their mouth and one eye? I mean, is that a collective effort, or is this just, your client's conduct?
Well, I think that in Healy v. James, they weren't specifically worried about the existence of a chapter per se, but rather that chapter's reputation for the ability to create violence. And so similarly, I think Dean Howard is worried about not a specific protest, but the idea of a protest causing a distraction.
But is he worried about a protest or a disruption? I mean, I feel like it's a pretty legitimate, reasonable interest for a university to want their students to be able to take exams without disruption.
Certainly, Your Honor, but of course that has to be tempered with the interest in protecting students' right to freedom of speech and freedom of protest. As we know, those are not only foundational constitutional rights, but also college universities tend to be the most prime location to express those rights. And so, as important as an academic period may be, or rather a final examination period may be, we're certainly not contesting that. It simply needs to be considered in light of taking students' First Amendment rights away. And when we examine this case in particular, where we see that no disruption was necessarily occurring as a result of Michael's protest before Dean Howard intervened, we can see that that behavior would not have caused any disruption, or at least it had not up until that point. And so that just has to be weighed against completely taking away students' freedom of protest as compared to a protest which did not necessarily cause any kind of disruption.
So how should the school have written the ban in this case?
Well, I think that they simply could have made alternate avenues available to the student body. For example, as I said earlier, when the policy was announced, it was effective immediately. Students weren't given any chance at all to protest in a warning period or a grace period. So first of all, they could have allowed students a period during which they could make their voices known. Moreover, they could have established specific areas on campus for protest specifically. They could have established particular periods of time, perhaps maximum noise levels, maximum occupancy counts. Simply banning all protests and demonstrations outright is just an extremely extreme solution, and plenty of alternate avenues were available.
But so is the argument then that they should have held some sort of public discussion about the actual policy here before they unrolled it?
I think not necessarily the student input, while that certainly would be valuable. The point that I'm particularly identifying is that students weren't given any kind of warning period during which they could protest.
But so was the policy released right at the precipice of exam time, or was there some sort of period in between? I guess I'm curious from the college's point of view. It feels like they had to put out the policy before exams, and so there was no period in between where they really could have had any sort of discussion or consideration of other avenues.
Well, I believe 2 weeks had elapsed between the travel ban being announced and when Dean Howard announced the ban on all demonstrations and protests. And so it seems to me that he could have simply said, shortly after the travel ban was announced, told the student body that a ban was going to be instituted, and if they wanted to protest and make their voices heard, that they should do so before the beginning of the final examination period. Now, Your Honor, turning to the first point that I mentioned, Dean Howard and Chief Tate were acting under the color of state law when they abused their authority to deprive Michael of his constitutional rights. Now, this claim for relief stems from 42 USCA 1983, which holds an actor liable wherever they are a state actor and wherever they use the badge of their authority to deprive an individual of their federally guaranteed rights. Now, as to the first point, Your Honor, we can close the door rather quickly because, as we know from Atkins, state employment is generally sufficient to render an actor a state actor.
Right. That's not even an issue for the court today. I think you can move on to your next point.
Perfect. Then we'll move on to the second issue, which is that Michael's conduct was inherently expressive speech. Now, as we know from Spence, conduct can be considered protected speech wherever the conduct is inherently expressive. Now, in Spence particularly, Spence affixed a peace sign to the American flag in protest of the Cambodian incursion, in addition to other protests. Now, the Cambodian incursion was at the forefront of the public mind at the time, and so the symbolism, when viewed in that context, breathed life into it and was able to convey a particularized message to any viewers. Now, of course, we will concede that none of the symbolism employed by Michael is quite as concrete as the peace sign, for example, employed by Spence. Its very name reveals the fact that the peace sign is as interchangeable with the concept of peace as the word itself. But nonetheless, Michael still employed concrete symbolism that is impossible to mistake. For example, the tape over his mouth. Obstruction of the mouth is a universally understood symbol for silence. For example, every day on my commute, I pass by a billboard of a woman with a pacifier in her mouth with the caption, "Silence sucks." It's a very well understood symbol that obstructing the mouth indicates silence. And so just as in Spence, how we had to look at the context, we need merely look at the context in the case at bar in order to breathe life into that concept of silence. Now, just as...
I'm confused about the relation between silence and the actual intended message, which was to protest the executive order with respect to immigration rights.
Certainly. So, again, if we look at the context in this case, well, the travel ban was at the forefront of the public mind. And we know that because, for example, as we've already discussed, DMU issued this policy in response to the travel ban. And moreover, as I also mentioned previously, the student body is being forced to choose between their education and their family. So it's also at the forefront of their mind. And so with that on their minds, they simply need to apply that to the idea of silence. And it seems that viewers would very readily be able to see that Michael regards the travel ban as silencing the immigrant voice because it is forcing these immigrants to stay out of the country should they decide to leave. And moreover, the other symbolism employed by Michael has also has some symbolic weight to it. For example, the tape over his eye could indicate how he feels as though President Wallace is blind to not see the value of the immigrant voice in this country. Moreover,
it's difficult, I think, for us to identify what the symbolism is specifically.
Mm-hmm.
I mean, he could have been protesting exams at the school. He could have been protesting any number of things that the administration was unrolling at that time. Why is it, and I get that he's an immigrant,
mm-hmm.
And 1/6 of the student body is of immigrant descent, but it's kind of hard to identify how that particular message comes across from your client's conduct.
Certainly. Well, I think it's important to note that in all precedent that has been identified in our briefs, all of these symbols are capable of a myriad of different interpretations. In Spence's case, for example, he was protesting the Cambodian incursion, but also the Kent State Massacre. And the court considered that to be clear. Well, why not one, or why not the other, or why not something else entirely? And it's clear that the context is always controlling in order to breathe life into that symbol. And because this travel ban is the forefront issue on the public mind at the time, certainly there are other issues, and we don't deny that, as you've already identified, and yet this issue was at the very forefront of the public mind because it was such a tumultuous issue. This was the only thing that was being talked about in the political sphere at the time, or at least the most important thing, because of the intense weight that it held.
So given the president here and the conduct, it seems day to day that there's a new issue every moment. And so I'm curious your point of view of how, if I walked by your client in that hallway, I would know specifically, he didn't say, I'm protesting the immigration ban. He wasn't wearing a shirt that said, say no to the ban. It's just these two items on his person.
Certainly.
How do we identify that?
Well, again, the standard is not that the message be absolutely incapable of any other explanation. It simply needs to be likely to be understood. And again, while there are alternate interpretations, I don't think we've ever seen a case where a symbol only has one interpretation. And again, it always seems to go to the most likely interpretation. And I think that because this travel ban was so vitally important to this community specifically, not only because the student body was so diverse, but also because the DMU administration had acknowledged the high fear of protest for it, it seemed very clear that the student body and the DMU administration was very aware of students' propensity to protest the travel ban.
I know we're over time, but I have one remaining question on an issue
Absolutely.
we haven't touched on yet, which is the forum for this particular protest
Mhm.
and the university's right to have reasonable restrictions on certain of its areas. Why would the university's restriction on protests in a hallway classroom, why should that not be upheld here?
Certainly. Well, again, this policy being a complete and total ban was entirely too broad and entirely unreasonable. Again, it is giving these students absolutely no alternate avenues to express themselves. Moreover, we can see that this policy was not reasonably necessary in order to achieve the interests that DMU held by virtue of the fact that Michael's protest was not disturbing anyone until Dean Howard intervened. And so the combination of this policy being so incredibly broad that students had no other options to express themselves, in tandem with the fact that students were not given any kind of warning period during which to make their voices heard, both contribute to making this an unreasonable policy.
Does this mean that no spaces were off limits at this point?
Absolutely not, Your Honor, and certainly we would not contend that students could not be screaming in the actual lecture hall in protest. There are certainly limits. However, the policy being a ban on any and all demonstrations and protests is too far-reaching. For example, say a student is sitting in his room and holding up a sign in protest. Certainly that's not going to disrupt anyone, nobody's around, and yet that would still fall within the purview of the ban because they are holding a demonstration or protest during the final examination period. And so there's just this incredibly huge continuum from the student sitting alone in his room to the student screaming inside the lecture hall where students are taking an exam. And while we certainly wouldn't contend that all protests are equally bad, some would simply not be disruptive to the student body, and that would be the kind that we see in Michael's case, for example, where he was sitting peacefully, not disrupting anyone, not barring anyone entry into the classroom.
Thank you, Counselor.
Thank you very much, Your Honor.
So I see we're over by 3 minutes. Can we allocate 3 additional minutes to the respondent, please?
Sure.
May it please the court, my name is Jocelyn Simpson and I represent the respondents. In order to determine if a person's First Amendment rights have been violated, the court must assess 3 things. First, if the conduct was protected by the First Amendment. Second, the nature of the forum. And third, whether the restriction met the standards for the forum. The respondent's position is that the district court correctly found that there was no violation of the petitioner's First Amendment because DMU enforced reasonable, narrowly tailored, non-discriminatory policies to preserve an orderly educational environment. So first, looking at the petitioner's conduct in this case. The petitioner showing up to his final exam with no shirt on, his mouth and eye taped, and standing in silence outside an exam room is not protected speech under the First Amendment. In Spence, we were told that conduct is speech when there's an intent to convey a particularized message and there's a likelihood that that message would be understood by those who received it. And the respondents aren't saying that the petitioner didn't intend to communicate a message because we believe he did, but we don't believe that there is a likelihood that the message was understood by those who received it. In cases like Spence and Tinker, students were using flags like symbols like the American flag and a black armband with a peace sign on it. Those are really powerful symbols that people walking by would likely understand, whereas in our case, duct tape over an eye and your shirt off, people walking by most likely did not understand what the petitioner was trying to convey.
What about in the school where, 1/6 of the population is of immigrant descent, and this is 2 weeks after the time period that your colleague alluded to. I mean, it seems like the context spells that if I'm walking by his client, I think one thing and one thing alone.
And that's fair, but the petitioner's behaviors were ambiguous and open to multiple interpretations based upon the context. For instance, the petitioner could be having a mental breakdown because of the exam period. He could be protesting the silence that DMU enforced on them. He could be protesting exams in general. So to say that the context of a president being elected 2 weeks ago and maybe having executive order is not the context that courts have talked about in the past. For instance, in Texas v. Johnson, that context was relevant because they were at the Republican National Convention. In this case, the petitioner is outside of a classroom during an exam period, so if anything, the message would likely be that he's protesting exams, not the election of President Wallace.
What was the context in Tinker?
I don't recall. I would have to get back to you on that. In conclusion, on that point, the petitioner's disruptive behavior is not worthy of First Amendment protection. The second criteria courts need to look at is the nature of the forum. DMU is not a public forum. DMU is a designated public forum with respect to its open space, its streets, its sidewalks, and its common areas, and a non-public forum with respect to its classroom and hallways. Even though DMU is publicly owned and managed, it's not open to the public, rather it's restricted to its students and its faculty. Government-owned property is not inherently a public forum, so courts need to examine the intent, the policies, and the traditional use of the property.
So what's the best cases for that argument that a hallway is not a public forum?
So Bowman and Putnam both discuss that case, and they discuss how a lot of places have a variety of forum within a designated space. So for instance, universities have a wide variety of fora. So auditoriums and stadiums, those are designated public fora because they welcome the public and speech and free flow of ideas, whereas the classroom and the hallways are for academic purposes, just for the faculty and students. And while they are for the free flow of ideas, it's for academic free flow of ideas.
But
Oh, please.
I was just going to ask one more question. So if I'm walking around the hallways of, say, my law school, there's a number of signs that are politically bent. And so it's hard for me to wrestle with the notion that hallways are not public forum.
That's a good point, but based on the case law, from what we have seen, it has been decided because classrooms and hallways are for academic purposes, although you can place signs up for the speech purposes, it's a non-public forum. Even if it were to be looked at as a designated public forum, DMU's policies still meet the test required for that type of forum, and so for a traditional designated forum, a time, place, and manner restriction can be placed if it's content neutral, narrowly tailored to achieve a significant government interest, and it leaves ample alternative channels of communication. And so in this case, DMU's policies do that. It's to further the significant or important interest of preserving a learning environment that's free of disruptions and unnecessary distractions, which is what the petitioner's conduct in this case was. In addition, it's unrelated to the suppression of students' speech. It's narrowly tailored, content, and viewpoint neutral.
Let's think about the narrowly tailored aspect of this.
Sure.
The policy did not distinguish between the public forum and the limited non-public forum, which you have identified for us. Why is that, and could the policy have been more narrowly tailored?
Arguably, it could have been, yes, but at the same time, because it's restricting the time, place, and manner, it's constitutionally valid because DMU was only restricting speech during that exam period. It wasn't a complete ban on speech in all types of campus for an undesignated period of time. It was just the exam period, and so DMU has the authority to place that type of ban.
I think, counsel, the risk that we run in ruling in your favor today is that next week there will be a case file where a college banned similar conduct for 6 months because they had exams on a rolling basis. And so I guess tell us, how do we fashion a ruling that actually does not open the floodgates to crazy colleges making crazy decisions around policies?
Right. I think it's going to be a case-by-case basis, just because in our case, first of all, the petitioner's conduct is not speech, because it didn't pass the Spence test. In addition, DMU has the important interest in preserving an environment that's free of disruptions and unnecessary distractions, especially during exam period, which is why students are at the university in the first place. They need to be taking these exams, they want to succeed, and to have someone protesting during that time, DMU has the authority to limit that. And in addition, DMU has the authority to suspend and place other disciplinary actions in response to the student's behavior, because it's rationally related to that legitimate interest in keeping an orderly educational environment.
I'd like to think about the neutrality of this ban. The court is not aware, and the record does not reflect any prior ban, which leads one to say that this ban is in fact targeted at the immigrant population. What can you say to convince the court that that is not the case here?
While it did happen at a time where that could be inferred, the policy didn't state a ban on protests about President Wallace or the executive order. The ban was for any type of protest. So there could have been people wanting to protest exams. There's just the ban on all protests during that exam period, so it wasn't targeting one specific audience.
But an academic institution in the United States these days, I would wager that 99% of the protests are exactly the type that we're dealing with here.
I think that's fair, but again, I think because of the time period and the context in which the protest was taking place in front of an exam room during the examination period, I'm not sure it's fair to say that DMU was targeting a specific audience when they made that policy.
So just one additional question. Besides the petitioner in this case, have other students been punished under this regulation?
I'm not sure about that, but I could submit an answer in writing if you would like an answer. The district court also correctly found that Dean Howard and Chief Tate were not acting under the color of state law and therefore did not willfully deprive the petitioner of his First Amendment rights when they removed him from the final exam area. And so the statute we're dealing with here states that if a state actor in his or her formal capacity willfully deprive a citizen of their constitutional right, then he or she, that individual, is responsible for the damages to that injured party. In this case, the plaintiff has the duty of proving that what he was doing was a constitutional right, and the respondent's position is that he did not. The state officials acting in this case, Dean Howard and Chief Tate, did not know that what they were doing was violating the petitioner's First Amendment right. They didn't know he was acting using his First Amendment right to protest. They didn't know what they were looking at. They thought they could be seeing the petitioner having a mental breakdown, so it wasn't clear at the time that the petitioner was exercising his First Amendment right of freedom of speech.
So is willfulness really an element here that needs to be proven?
I don't believe so. I think the most important part of this is that the state actors knew they were violating, willful is, they had to know they were violating the petitioner's First Amendment right. So because they didn't know that they were violating the petitioner's First Amendment right, they didn't willfully deprive him of that right.
So I'm curious, your colleague made a big point of his brief on state action and arguing that this was state action. Do you concede that this is state action?
Yes, I do concede that this is state action. Dean Howard and Chief Tate were both acting in their position as a state actor through the university during when they removed the petitioner from the outside of the classroom.
Mm-hmm.
But the petitioner's conduct wasn't known protected First Amendment rights, so they couldn't be willfully depriving him of that First Amendment right. And so, in conclusion, if the petitioner's conduct is not protected by the First Amendment because his message was not understandable to those around him, and his behavior was disruptive to the learning environment, Dean Howard and Chief Tate were not acting under the color of state law when they removed the petitioner from the hallway, and Dean Howard and Chief Tate's actions were rationally related to the university's legitimate interest in providing a final examination period free of disruption and distraction. The respondents respectfully request this court to affirm the district court's decision and deny the petitioner's request for injunctive relief. If there are no other questions.
Yeah, I'd like to talk to you for a moment about the resulting punishment that was handed out by the school to the student. It was a failure in the course and then a 2-semester suspension. That strikes me as very severe. How is that punishment justified?
DMU has the authority to suspend a student or use other disciplinary actions if the student's conduct created a substantial and material disruption to the school's daily activities. And so in this case, the petitioner arguably did create a substantial disruption because a group of 25 students were gathered, 25 or more students were gathered outside the exam when it's supposed to be quiet for the students to be taking the exam. The petitioner took away the attention of a professor who was supposed to be administering the exam. The petitioner took away the dean, who is supposed to be making sure exams are going well, that everything is going as it is supposed to, and so instead all eyes were focused on the petitioner, causing a substantial disruption to the typical examination period criteria.
Yeah, I mean, it seems like your argument too is that the disruption was of such an effect that students on financial aid, students who are there on scholarship, all are at risk for failing the exam, which could lead to everyone else in that class possibly being booted out of school, right?
Somewhat, yes. We're basically saying that this conduct was distracting all students. Anyone who walked by was looking at what the petitioner was doing, not focusing on their exam, taking their head out of, taking the exam. And so this was a distraction to the students, the professors, and the dean in this case. And so when that kind of conduct occurs, the university does have the right to suspend a student.
Was there anything in the trial record about other students failing that test or anything to the effect of the disruption?
There was not. Just about the group of students gathered around him. And we don't know if those students were supposed to be in an exam, if they were supposed to be studying, so it could have led to a lot of distractions and disruptions.
Do you dispute the petitioner's contention that the students gathered only after the officer and dean arrived?
I don't think that is in the facts. I think that there were students gathered around before the dean arrived, and then the group just happened to grow once the dean arrived. There are no other questions.
Thanks so much.
Thank you.
Thank you, Police Court, Your Honor. Your Honor, at this time I'd like to challenge a few of the factual statements made by the respondent. First of all, the respondent argues that Dean Howard and Chief Tate perhaps thought that Michael was having a medical emergency, which frankly is completely unsupported by the facts of this case. Not only did they immediately punish him after taking him away from the scene, which seems to be an odd response to a medical emergency, but moreover, I would ask why they didn't call any medical professionals if they had any kind of suspicion that Michael was having a medical episode.
Yeah, I think the point to her argument, though, wasn't so much that it might have been a medical emergency as then it could have been anything under the sun besides a specific protest of the immigration ban.
Mm-hmm. Well, because it's clear that it wasn't any kind of medical emergency, viewers at least knew certainly that it was some kind of protest. And again, when we take that concrete symbolism of the tape over his mouth indicating silence, and the context of this travel ban being at the forefront of the public mind, it seems a very short leap to associate that silence and associate with the message that President Wallace's ban is silencing the immigrant population. Again, this is an incredibly diverse student body. The facts that I've already cited support the fact that this demonstration ban was instituted responsive to the travel ban. It's very clear that there's a high propensity for students to be protesting the travel ban.
Counsel, can I ask you a question about your argument and the flow of your argument? Why the focus on the state actor piece? I mean, if your colleague concedes that point, I'm just wondering why it's a topic of conversation for the court today.
Do you mean the fact that Dean Howard and Chief Tate were state actors, or the fact that they were acting under the color of state law? Well, being a state actor is a critical element of acting under the color of state law. Mm-hmm. And as to acting under the color of state law, as we've already established, or as I've contended, Michael had a protected right to freedom of speech and freedom to express himself. And Chief Tate and Dean Howard robbed him of that when they used their authority to violently end Michael's protest.
Do you feel like your client was targeted? I mean, to my colleague's question, mm-hmm. There's nothing in the record about other people being punished for a violation of this policy.
Certainly.
So do you feel like your client was targeted or made an example of?
I don't think that he was made an example of, but I think that his viewpoint was certainly targeted in as much as, by the very nature of protests, they are most effective and arguably only effective when an issue is at the forefront of the public mind. And so this travel ban having just been announced, there was an incredibly critical period during which any protests had to be performed during that period in order to gain any kind of traction. And this ban, while only nominally for the duration of the final examination period, really was going to last for about 4 times as long. And the reason for that is that, as we all know, after the final examination period, the winter break begins and students disperse. So with nobody to protest and nobody to observe the protest, the student body is not just being silenced for a week or however long the examination period is, but in fact perhaps a month and a half until the next semester begins. And frankly, at that point, the issue may not be completely out of the public mind, but that critical period during which positive change can be effected has passed by already. Thank you very much, Your Honor. And again, we pray that you find for the petitioner.